Okay, welcome back, everybody. Welcome back to everyone. This is your favorite show, PeacePathChannel. I am back. I'm so sorry for the long silence. We have been trying to dot the I's and crossing the T's so that the channel can fully, it's a podcast, so it can fully roll. This is your favorite channel, and this is your favorite Judith Paxson. I'm here again on the same topic, ADR, alternative dispute resolution. I keep getting this question on why is ADR taking the justice space. As we all know, we are living in time where speed, efficiency, and relationships define success, not just in business. A relationship as speed. In fact, the most important thing is your relationship defines success. How does your relationship define success? You can't be at dispute. You can't be conflicting with yourself and expect success. You can't be at conflict with others and expect success. The Bible does not even encourage it at all. Tradition does not encourage it. Where there is so much conflict, dispute, you see success is hampered. Success is destroyed, if not in totality. So we are going to explore and look at why is ADR taking over the justice space. Stay tuned as we continue after the short break. Yeah, welcome back from the short break. Now let's look at why ADR is taking over the space of justice system in the world, not just in Bayelsa, not just in Nigeria, but worldwide. I am a member of the Nigerian Institute of Chartered Arbitrators, NICAP, MCAP, and a member of Institute of Chartered Mediators and Conciliators. So I shall have ideas on why alternative dispute resolution is taking over the justice space, right? Yes, I guess that the answer is yes, because I'm trained. So I will tell you. Now, the traditional courtroom was once seen as the ultimate temple of justice. We all know that the traditional courtroom system was seen the superior ultimate avenue where we can resolve our disputes. You go to the streets, you hear people at conflict, they tell you we'll see in court. When you hear people fighting and the fight is getting overboard, you hear them say we will see in court, we will meet in court. But things are now tilting towards a more flexible way of resolving disputes, a more convenient way of resolving these disputes. These convenient ways, convenient areas are now challenging that once seen ultimate medium of settling dispute. And what is this other way? It is alternative dispute resolution mechanisms, ADR. That is what is now evolving, and it is about taking over the justice space of resolving disputes. Now, ADR is not just an option anymore, because a lot of people are looking for peace. A lot of people want peace. A lot of people want easier, most convenient ways they can resolve disputes. I have had situations where people have asked me, parties have asked me, must we go to court? Must we go to court? I tell them, no, you mustn't go to court. It's not a must. If you do not want to go to court, then you don't want to go to court. You can resolve your dispute in other ways. There are other areas, there are other doors you can resolve your dispute without running through the courtroom door. A lot of persons are getting tired of the justice system. A lot of persons are no longer comfortable resolving their dispute through the courtroom system. A lot of persons are feeling biased. A lot of persons are feeling they are wasting their time, their resources, their monies going through the courtroom door. Imagine that you have a land dispute, and that dispute, which is supposed to take a minimum of 3 months to resolve, is taking forever because of our laws. It's taking forever. Litigants are busy looking for evidences here and there, looking for witnesses here and there, and then you come back to the courtroom, the instant adjournment, you come to court, it is either the judge has traveled unavoidably, or the judge is adjourning your matter because of one issue, of course, from the side of counsels, or most times from the litigants. Probably the witness did not come to court, or the witness is very far, especially in Bayelsa, where we have witnesses that stays in the creeks, in the water areas, where they don't get access the courtroom easily. It takes them maybe a day or two to come down. Sometimes cost of transportation. Yes, I am from Bayelsa and I know the cost of transportation through the waterways for those who are living in the village area. I beg your pardon. For those who are living in the creeks. So you hear litigants complaining, I couldn't come, or the lawyer complaining to the court that I tried calling the litigant, the witness's number, his number is not connecting. You know, the issue of network. Of course, network is not just good in everywhere in Nigeria, but it is worse in the remote villages. A lot of people are getting tired. They are getting tired. A land dispute, all the litigants are dead. And then you see their heirs taking over the same problem, inheriting the same dispute to continue with it in court. People are overwhelmed. People are tired. So they are now asking, are there other ways we can resolve our dispute aside litigation? And I say, yes, there are more convenient, comfortable, cost-effective ways of resolving your dispute without going to court. Now, ADR is becoming the most preferred part, whether you like it or not. I know my fellow lawyers will want to crucify me. You want to take food out of the mouth, those are into court litigation. No, there are still some cases that requires litigation. But I tell you, any matter can be mediated upon. I tell you, any matter can be mediated upon. Now, in case of criminal matters, you see a lawyer talking to the complainant, at the same time talking to the victim. What is that lawyer doing? You are simply mediating. Because I'm sure you're not talking to the complainant and go and kill the perpetrator of that act. You're not saying so. You are mediating. So whether you like it or not, I say any matter can be mediated. Or let's be honest, litigation is no longer working the way society needs it. Yes, litigation is no longer working the way society wants it to work. From the lower courts to the Supreme Court. Is it the Supreme Court when you go to Supreme Court and they adjourn your matter 5 years later? Of what use is that matter? Of what use is that dispute? Personally, that dispute is no longer of use to me. If I should wait for the next 5 years, assuming the litigant is an 80-year-old man and his matter has been adjourned to the next 5 years, are you telling me that the litigant will feel much alive till that 5 years? He's already in the evening of his life. So waiting another 5 years looks like waiting for eternity to him. So tell me, won't that litigant choose ADR to resolve his dispute instead of going that route? Yes, court systems across the world, especially in jurisdictions like Nigeria, are plagued by endless delays, procedural bottlenecks, high legal costs, technicalities that often defeat justice. Yes, in Nigeria, I tell you, you see all these things I just mentioned. These are some of the things that defeat justice in Nigeria. Technicalities, endless delays, incessant adjournments, procedural bottlenecks. They defeat justice in Nigeria. So a lot of people are tired. I have had people who come to me and ask me a lot of questions. Questions like, can't our matter be resolved within 2 months? Can't this matter be resolved within 3 months? Must our matter linger for 5 years? Must our matter linger for 10 years? When will this dispute be resolved? Now, as a core litigation lawyer, how do you answer this question? Are you going to start arousing expectations from, or in your clients rather? Are you going to be arousing hopes, false hopes, that don't worry, within 6 months highest, your matter is resolved? Who told you that? What happens to the incessant adjournments, delays, procedural bottlenecks, and all the technicalities involved in that matter? You are not the only counsel in that matter, remember. If you don't want delay, the other counsel may love the delay. Why? Because if he finishes that matter on time, I bet you he probably does not have other cases to do anymore. So his appearance fee is going to stop. My apologies to litigation lawyers. Apologies. I'm also a litigation lawyer, you know. But I want us to look at resolving conflicts from different perspectives. What is the reason behind PeacePathChannel? Our reason is we must ensure that peace returns to the society. We must ensure that disputes are resolved, conflicts are resolved in peaceful manners, where all parties go home smiling, not where all parties are going back home thinking of the next evil to mate on the other party, not thinking of appeal, but going back home with the mindset that, oh, my dispute was resolved. Justice delay, as we all know, is justice denied. If justice is delayed, the justice is denied. Let's take a clue from the example I gave about the 80-year-old man, that his judgment is to be adjourned for the next 5 years, or to the next 5 years. He couldn't get justice until probably, just maybe, he meets his ninth. Has justice not been denied? Justice was delayed. Has justice not been denied? Justice has been denied. So you see, we all must come together, put our hands together to ensure that ADR works perfectly in this society where we live in. ADR steps in as a solution to a broken system. Yes, that is where ADR comes in. Whether you like it or not, the justice system in Nigeria is broken. And we need to amend the justice system by other means of resolving this dispute. When your dress is torn, what do you use to amend it? Do you cut another part of that dress to amend that dress? No. You get a thread to amend it, either with the help of a needle or a sewing machine. So here the justice system, which is a traditional court litigation, is broken, and we need to amend it with another thread. And what is our thread here? ADR. We need to amend it. Of course, in the society today, disputes must happen. People must have conflict with themselves. People must fight. You can't take away that from the society. Even you can fight with yourself. But how do you resolve this? How do you resolve this conflict? Must it go through the courtroom doors? Must it go through all that denial process? No. We have to look at other areas where these disputes can be resolved. In today's fast-paced world, time is of essence. Time is money. You waste your time, you've wasted money. You're going to court every day. You're going to be paying your lawyer appearance fee. You're going to be spending money for your transportation, assuming you're coming from a very distant place to the courts. You're going to be wasting time, wasting money. So let's know that in this modern age, time is of essence. Let's look at other ways we can amend our broken traditional system. Stay tuned, as I will be right back after this short break. So welcome back. We're going to continue our topic, why is ADR taking over the justice space? Like we said earlier, time is money, so we don't need to waste it. Now, businesses cannot afford to wait for years to resolve disputes. No. They will be losing a lot of cash. They will be losing a lot of clients, losing a lot of customers. We can't put our businesses on hold because of disputes. No. And that is the reason why we have commercial dispute resolution centers. Commercial, the word commercial, what does it say to you? It's telling you that these are resolution centers made for businesses to resolve to resolve disputes among business owners within and outside organizations. We can't put our businesses on hold because we are doing one court battle somewhere. You file a case in court, the other counsel files, the other party will come and file for stay, or even if it's not for stay, for let parties maintain status quo. Yes, that's the word. Parties should maintain status quo. Now, if parties are maintaining status quo, how will the business move forward? We should put the business on hold because there is one dispute that can easily be resolved among members, among parties, I beg your pardon. No. Let's find a way to resolve dispute. Families cannot endure prolonged emotional battles. No, it's not healthy at all. Governments cannot function effectively with unresolved conflicts. Businesses cannot be put on hold because of conflicts. Families cannot be stagnant because of conflicts. Governments cannot also be stagnant because of conflict. It will destroy the nation. There are dispute resolution centers everywhere, even internationally. There are dispute resolution centers everywhere that can resolve our disputes. We have ADR mechanisms such as arbitration, mediation, negotiation, conciliation. These are all ADR mechanisms we can use, we can take advantage of to resolve our disputes without running through the court doors. Yes. Let's have a rethink on our method of dispute resolutions. We can use any of them. Although, yes, arbitration, it's like a mini litigation, but it's also party friendly, where the outcome is an arbitral award, while you get judgment in litigation. Mediation is another route, another door you can resolve your dispute. And what is the outcome of it? You have mediation agreement. Both parties agree to the terms and you sign. A lot of us are engaged, a lot of litigation lawyers are engaged in mediation unknowingly. When we say, oh, parties, oh, my lord, parties are in talking terms, they are trying to agree so they could file their terms of settlement. You don't know that is a mediation agreement. Yes, their terms of settlement is a mediation agreement. Just that the document is now called terms of settlement. The lawyer or the lawyers involved in this dispute have been mediating between parties to see how they can come to terms. They now agree on particular terms and then resolve that, oh, we are settling out of court. And all the lawyer does is go to court and inform the court that, oh, my lord, parties have settled and they filed their terms, and requesting the court to enter those terms as consent judgments. Now, it has reduced the number of times those parties would have appeared in court. It has also reduced the number of times they would have paid their lawyers appearance fees. It has reduced the time technicalities would have arisen, if not eliminated it completely. Within a short period of time, parties go home happy. Why? Because judgment was not entered in the favor of anybody. Parties have agreed. This is how we want it and this is how it should be done. Mediation is party driven. The parties discuss and settle their issues out of court. They are not waiting for any judge to deliver judgment. Of course, the judges deliver judgment according to the law, but mediation is party driven. The mediator is just there to guide them on ways to resolve their dispute. He is not to tell them what they should say, what they should write, and what they should do to resolve this dispute. He is to guide them. That's the role of the mediator. He listens to both parties and suggests areas the parties can shift grounds and then come back together and settle this matter amicably. Party A, what do you want? How do you see this thing? What if you see it from this angle? What do you think? Party B, look at this matter from this angle. What do you think? In my previous video, in my introductory video, I told us that emotions are the reason behind disputes. We are all fighting for our emotions. We all want our emotions. We all bring forward our emotions selfishly without considering the emotion of the other. That is the reason behind disputes. Sometimes we keep the matter aside and our emotions are in the forefront. But with mediation, with a mediator or mediators interfering, I bet you the parties can see through their emotions and understand that, oh, these disputes, this battle does not worth it. Believe you me, the battle does not worth it. The settlement, the resolution is just before them, but they can't see it because their emotions are in the forefront. Yes, because their emotions are in the forefront. You see all these ADR mechanisms I just mentioned: mediation, arbitration, conciliation, negotiation. They offer timely resolution, sometimes within days or weeks. Trust me, it depends on the kind of disputes. Sometimes I have mediated on a matter that took just 2 days and we resolved. Yes, we got a resolution within 2 days. I have mediated over dispute that took just 2 weeks to resolve. Imagine if parties were, we are going to court. Do you think these matters would have been resolved within 2 months? No. But parties resolved that these matters must be resolved within this period. And it was so. Till today, both parties went home happily. That is what we want to bring into the society. PeacePathChannel is here to educate the society on possible areas they can resolve their dispute without courtroom battles. If you're a Christian, you know that Jesus Christ is a mediator. So you should aspire to be one. That is by the way. So we'll continue. Litigation is expensive. We all know that. If you have ever gone to courtroom before, if you have ever taken a matter to court before, you will understand that litigation is very, very expensive. Not just the professional fees you are paying. You have other appurtenances coming with the professional fees. The time lost, the emotions that have been twisted, the lives that got lost in the midst of this battle. Is that not expensive? When we say litigation is expensive, we don't mean just finances alone. It is more expensive to lose a life than to lose money. You can't lose a life in ADR. No. You can't lose a life in ADR. So I tell you, litigation is very expensive, and we should endeavor to choose other peaceful resolution mechanisms. Stay tuned. We'll be right back after the short break. Welcome back. This is still your favorite show, PeacePathChannel, and we have been exploring the topic, why is ADR taking over the justice space? And then we're on to effectiveness, justice without financial burden. Cost effectiveness, justice without financial burden. ADR is cost effective. It does not hang financial burdens on the parties. What are those financial burdens? You're paying litigation, professional fees. When I said litigation is expensive, before we went on the short break, when I said litigation is expensive, we're including filing fees, professional fees, which is the lawyer's fee, and we're also including endless adjournments. Like I said earlier, endless adjournment. Litigation is expensive. You lose life, is even more expensive. Hatred, acrimonies, name it. All sorts of evil comes with litigation. Now, ADR, on the other hand, is flexible, less formal, and less expensive. it is flexible, less formal, and less expensive. How is ADR flexible? It is flexible because it is party driven. Yes, ADR is flexible because parties get to choose, number one, their mediator. In the case of arbitration, parties get to choose their arbitrator or arbitrators in the case of more than one arbitrator. But in the court system, parties are not allowed to choose who their judge is. When your cases are filed, the chief judge assigns your matter to any court she desires to handle that matter. And you must appear in that court, whether you loved the judge or not, whether you like the judge or not. But in ADR, alternative dispute resolution, the case is different. It is flexible. Parties get to choose who mediates on their matter. They get to choose the arbitrator or arbitrators in the case of more than one arbitrator. And in the event that they feel the arbitrator is becoming biased or the mediator is becoming biased, the parties are at liberty to choose another arbitrator to mediate on their cases. Arbitrator to arbitrate on their matter, and the mediator to mediate on their cases. Yes, that is the way it works. So it's flexible. Parties get to make their choices as against the normal courtroom litigation where parties do not have choices to make. Whatever that is offered to them is what they collect, whether they like it or not. Which do you prefer? Less formal. Parties come to ADR relaxed. No issues of cross-examinations, strict cross-examinations. No issues of bring your evidences, name them as exhibits. Exhibit 1, Exhibit 2. Keep it with the exhibit keeper. You see, all those formalities that comes with litigation does not come with ADR. It's less formal. In the case where a party wants a legal representative, a lawyer who is also a mediator, to represent him or her, the lawyer must not dress like he's going into the courtroom. He can dress formal, but he has to pull litigation cap away from his head and wear that of a mediator or an arbitrator. So it is less formal. No wig and gown, no formal court setting. Sometimes we just sit on a round table and we discuss, dialoguing. We discuss as friends. I have mediated over a case where in the beginning, when the party A came in, party B got to the door and decided to run out. No. If this person is here, I can't sit here. I can't sit here. Ma, please forgive me, I can't sit here. I had to sit my mediator's cap properly on my head and persuade that party B to come in, feel relaxed and sit. And that happened. Guess what? Both parties went back smiling with themselves. That is what mediation can do. Assuming it was litigation, would that have happened? No. I will show you that I have the best lawyer. I will show you that I have evidences against you. Animosity grows. Hatred grows. Inherited by their heirs. Their descendants inherit it. Is that what we want for our society? Is that what we really want? sense of reasoning? I bet no is the answer. Now, what does ADR does? It opens the door to justice for people who would otherwise be priced out of the legal system. That is what ADR does. Secondly, ADR is not just efficient, it is inclusive. It is not just efficient. It's not the efficiency of the, and like I told us before, ADR is party driven. It is inclusive. It brings parties in to discuss their disputes, to discuss their emotions. It does not tell them what the law says, this is what the law says, and that is what you are going to do. It distinguishes the emotions of the party from the dispute itself, and make the parties understand that their emotions are different from the dispute that is before them. It is all inclusive, party driven. Now, what does ADR do again? It preserves the relationship of all parties. ADR keep our relationships intact. Alternative dispute resolution mechanisms foster relationships between parties. Assuming that 80-year-old man says, no, I don't want the matter. Probably the matter started when he was even 70 or 75, thereabouts, and the matter has lingered in the lower court for 5 years before it got to Supreme Court. If he was 70, the matter must have spent 5 years at the High Court, another 5 years at the Court of Appeal, and then wants to spend another 5 years at the Supreme Court or more. Tell me, will he get justice even before he meets his nights, or he goes to sleep finally? No. If that man had chosen ADR, he would have eaten the fruits of his disputes even before he would have gotten to 70 or 80 years. The matter would not have lingered that long, assuming the man did not live up to the 5 years the Supreme Court gave and dies. Definitely, his heirs, his descendants, his children will see to the end of that matter. You know why? Disunity has been injected into those children. Retaliation has been injected into them. Peace is priceless. Peace is priceless. And battles, fighting is senseless. That's the way I put it. Preservation of relationships. That is one thing, or rather another thing ADR does. Let's try as much as we can to preserve the relationship of parties that are in disputes. One of the greatest tragedies of litigation is this: it turns disagreement into destruction. Yes. It turns disagreement into destruction. By the time a case ends, relationships are often beyond repair. Yes. By the time case ends, relationships are often beyond repairs. It has escalated beyond repairs. Their dispute has escalated beyond repair. ADR steps in before dispute escalates. If you have dispute with anyone and you decide that, oh, this dispute must not escalate, at the baby stage of that dispute, as the initial stage of that dispute, the mediator, you look for an arbitrator. Of course, any problem has a solution, and you must look for that solution before you get that solution. So if you do that, you ensure that your dispute will not escalate beyond repairing that relationship. ADR changes the narrative. Yes. Most of our court battles end up having long time enmity between family members, between community members, between friends, even with yourself. You become enemy to yourself. You know, when as a person you're having psychological issues, you know you are not well. Of course, you will know if you're not well. You will certainly look for somebody to talk to, somebody who can counsel you. What are you doing? You are trying to look for a solution to yourself. A lot of persons are at conflict with themselves. That is why we hear cases of suicide. They didn't bring out their conflicts. They didn't tell anybody what they're going through. They kept their emotions to themselves. And at the end of the day, they tell themselves, there is no solution to my problem. Let me just die. I see litigation to be one of such problems. Through mediation and negotiation, parties are encouraged. Yes, parties are encouraged to communicate, find common ground, and understand each other. That is what ADR does. They communicate, understand each other, and find common ground to settle their dispute. That is what I refer to as terms of settlement that lawyers usually inform the courts that parties want to settle out of. But they are looking for common grounds to settle their disputes. Yes, parties must ensure that they find common grounds to settle their disputes. If you are in point A, I'm in point B, do you know that our angles are different? And the way I see this dispute is different. You are standing on an angle that is different from mine, so you will see the dispute different from mine. If we can put ourselves in the other person's shoe, we will understand that, wow, this dispute is not even the way I saw it. That is what brings emotions down. Number 6, if it's standing, if I'm standing that way, you are standing this way, and 6 is written. To you, 6 is 9. To me, it is 6. Yes. You look at the number on the floor. Because you are standing at the other angle, you say that is number 9. And I will argue that this is number 6. That is the different points at which we are standing. That is what brings about disputes. If we can shift to the middle and look at the number properly, we will know that it is either that number on the ground is 6 or 9. There wouldn't have been any arguments. In businesses, this means partnership are preserved. Where partners come together and find common ground to resolve their dispute, that partnership can be preserved. When partners are in dispute over a particular issue, that partnership is heading to destruction. Communication is what ADR encourages. better communication is what ADR encourages. Instead of telling a person, hey, you talk too much, why not say, hey, you are so chatty? Isn't that mild? It won't trigger anger from the other person, is that not so? But when you tell somebody, hey, you talk too much, it triggers anger. That is how dispute starts. If we can communicate properly, we can also avoid disputes. In families, it means healing is possible. Healing is possible in families if we can communicate effectively, if we can communicate properly. The Bible says we should be slow to speak, but swift to hear. Why did the Bible say you should be slow to speak? You should think before you talk. Soft answer, the Bible says, driveth away wrath. What is wrath? Fights, disputes, quarrel. But when you answer harshly, you are calling for what? Dispute. Hey, you talk too much. And the other party is angry. Now why would you tell me I talk too much? It means a lot to him, right? But when you say, hey, you are so chatty, the other party will do what? Smile at what you just said. It does not foster disputes. ADR is not all about winning. I want to assure you that with our discussion on ADR on this channel, we're not telling you that it is all about winning. It is about resolving. It is about what? Resolving. ADR is about resolving. It's not about winning. Unlike the courtroom litigation where winning is at the forefront of every party, I must win this case. That is why I call it battle. You know, if you're in the forefront of any battle, what the goal is in your mind, the goal that comes to your mind is winning. I must win this battle. But with ADR, no. Resolving is what is at the forefront. We want, how do we resolve these disputes? The parties will all dismiss peacefully and becomes friends, and their relationship is preserved. How do we do it? That is what ADR is all about. ADR offers something litigation cannot. Do you want to know it? ADR offers something litigation cannot. That is confidentiality and privacy. Yes. ADR offers confidentiality of parties, privacy. Unlike the courtroom litigation where there is no confidentiality, your judgment in the courts is a public document. Anybody can apply to get a copy. The trial going on in the courtroom is a public place where you don't restrict people from coming in because your case is being handled or your case is called. But with ADR, there is confidentiality. Parties state how and where they choose their place. Yes, they choose the place, they choose the law to govern their case. Confidentiality, privacy. If the parties to the mediation says, oh, I want a mediation section to take place inside your office, we don't want anybody coming in, so be it. That is the privacy we are talking about. That is the confidentiality we are talking about. And everything that was mediated there stays there. It does not go anywhere. Nobody from the public has the right to call for or apply for those documents. See you right after the short break. Hi, welcome back. We're talking about ADR that offers confidentiality and privacy as against the courtroom litigation. That is one thing that litigation cannot offer you, privacy and confidentiality. But ADR offers you that in full dose. Yes. Court proceedings are public. Anybody from the public can apply to get those proceedings. Anybody, when I mean anybody from the public can apply because they are public documents. And your case, your matter has gone public, even to the hearing, even to the seeing or reading of people you never wanted them to know that your matter was in court. Yes. But you see, ADR, nobody does that. Nobody knew your matter was mediated upon or arbitrated upon because the public cannot apply to get documents of what transpired inside that room. That is what ADR can offer you. This is especially important in commercial disputes, family matters, intellectual property issues. Parties can resolve disputes without damaging reputation or exposing secrets. Yes. In litigation, you will expose everything. You will say everything. You will say everything. Even the darkest part of the story, you will say it. Because you are furious, you are angry, you want to say everything inside of you, even to the extent of what you would regret saying later. You will say everything. But you see ADR. ADR will resolve your dispute without damaging your reputation or exposing your secrets. There is something called caucusing in mediation. If party A decides to tell their mediator a secret, it is now the duty of the mediator to fine-tune that secret without telling party B exactly what party A did, without even giving party B a clue. Yes, that is how confidential mediation can be. Party B will not even hear your secrets. Party A will not hear party B's secrets. Party B will not get to know what party A's secret is. That is what ADR can do for you. In litigation, you are in the public domain. You are in the public view. You will say everything to the hearing of the public. So there is no secrecy. There is no privacy in litigation. Choose ADR. You will be grateful that you choose wisely. Another thing, another benefit of using ADR is flexibility and party autonomy. Of course, I've explained that before, that ADR is party driven. Flexibility and party autonomy. Yes. How flexible the whole process can be. If we try to resolve the dispute today, and we're making progress. We have not reached settlement. We can both agree, parties can both agree. Let's come back next tomorrow. Party A says, oh, next tomorrow, 10 a.m. will not be convenient for me. Party B says, let's do 12 p.m. And Party B says, oh, well, 12 p.m. is convenient. They go ahead with it. In the courtroom, if your matter is adjourned, sometimes the court can adjourn it to the date that is convenient for him, but might not be convenient for you, the parties. You don't have a choice than to come. Is that flexible? It's never flexible. Sometimes the judge can tell you, counsel, bring your witnesses. 5th, 6th, 7th, 8th. All your witnesses must be in court. What if your witnesses are all scattered in the remote riverine areas where it's not easy for them to come into the town where the court is situated? How do you gather those witnesses? You see, it's not flexible. If there are witnesses in arbitration, there is still flexibility. You can inform the arbitrator or arbitrators the situation and the predicament of those witnesses, and everyone will agree on convenient dates and time. But in courtroom, you can't just, that leverage is not strictly there. That flexibility is not there. Whether you like it or not, your witnesses must come to court. We're not bargaining it. And where your witnesses did not come to court, of course, the litigation lawyers understand what I'm saying. It is either the court slams you with costs, which you must pay before the next adjourned date for stricter judges. So you see, litigation is not cheap. It's never cheap. It's never cheap. It's very, 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 very expensive to deal with. Parties, like I earlier mentioned, can choose their arbitrator. They can choose their mediator, decide the procedure, control the outcome of the process. So you can see that it is very easy to settle your dispute through ADR mechanisms. Very easy. Very, very easy. This sense of ownership increases satisfaction and compliance. Telling parties that you are in total control of the whole process keeps them at ease. They get satisfied and they comply with all the rules of the process. It gives the parties a very high level of satisfaction that their cases are being resolved amicably. Excuse me. That is what ADR does. Let's look at ADR as a means to resolve a dispute instead of the courtroom battles parties go through every day. People are more likely to honor decisions they helped create. That is interesting, right? They honor decisions that they helped to create. If we have agreed on a thing, it will be difficult for you to do otherwise, because you also were a party to creating that agreement. Yes. It's very easy for compliance. it's very easy for parties to adhere to an agreement they were involved in. If you were never included in an agreement, you will fight. I never agreed to this, I never agreed to that, so I won't take this, I won't take that. But from the beginning, from the whole process, parties were involved. They are made to understand that this is your process, this is your matter, this is your resolution route. Take it serious. That is how disputes are resolved amicably. Now, another benefit of ADR is global acceptance. Global acceptance and enforcement. ADR is accepted globally, not just in Bayelsa, not just in Nigeria, but globally. We have the International Court of Arbitration. What does the international word mean to you? Does it not mean global? We have the ICC, International Commercial Courts, and a host of others. ADR is internationally recognized, internationally accepted, and internationally practiced. So wherever you go to, you can find ADR bodies, ADR resolution houses. For those in Bayelsa, we have the multi-door courthouse. That is where ADR issues are resolved. Just like other states that also have the multi-door courthouse where disputes are resolved. On this podcast, we shall bring in experts, other experts, to discuss on more important topics. ADR is not just local, it's global, like I said earlier. For instance, arbitration awards are enforceable internationally under frameworks like the New York Convention on the Recognition and Enforcement of Foreign Arbitral Award. Does that ring a bell to you? This makes ADR the backbone of international commerce. So let's know that businesses trust ADR because it works across borders, inter-country, interstates. Globally, ADR works everywhere. That is why a lot of businesses are now tilting towards ADR to settle their disputes instead of running through the courtroom doors and go through a process that will stall their businesses or cripple their businesses. Businesses cannot stand still because of disputes, because of many disputes that can be resolved amicably through one of the ADR mechanisms. No. The justice system must regain its sanity. Why is ADR taking the justice system? We have another benefit. The rise of technology and online dispute resolution. That is ODR. I mentioned it in our introductory video, where you can stay wherever you are. The mediator can be where he is, the other party can be where he or she is, and your dispute is being resolved together. That is online dispute resolution. It does not matter if you are in Nigeria, it does not matter if the other party is in US, and it does not matter if the arbitrator is in Ghana. All parties need to do is agree on time, agree on convenient time. This process can begin. We can resolve our disputes wherever we are. We must not be physical to resolve our disputes. We must not come and gather in a physical place to resolve our dispute. That is what technology has done. Imagine technology. ADR can be resolved online. We are entering a digital age where disputes can be resolved without physical presence. Did I say we are entering? We have entered a digital age where disputes can be resolved without the presence of all parties, including the mediator, including the arbitrator, including the negotiator, including the conciliator. We can resolve our disputes online. We can take advantage of any of these mechanisms to resolve our disputes without our physical presence. Online dispute resolutions, ODR, allows for virtual mediation, digital arbitration, cross-border settlements. Those are some of the benefits online dispute resolution has brought. Virtual mediation, you can be where you are, the other party can be where he is. The mediators, in case of two, or arbitrators, in case of two, mediator one, arbitrators two or more, can also be online. And virtually, thank God we have Zoom and a host of other apps we can use. We have Google Meet, we have Zoom, we have a lot of applications we could use online to ensure that our disputes are settled without our physical presence. You know, with this evolving technology, ADR is also evolving with the technology, making it even more efficient and accessible. So parties do not have the excuse of say, oh, I don't have transport to the mediator's office or to the agreed venue. That is why I could not come. No. Parties do not have that excuse. Or the mediator say, oh, I couldn't make it because the downpouring was too heavy. I don't drive when the rainpour is too heavy. No any form of excuse. All we need to do is schedule time. Except for the fact that, of course, network telecommunication can be so funny sometimes, not all the time though, that you try to connect, it will kick you out. Which is not nobody's fault, not the fault of any party. But more often than not, parties can be wherever they are and their process can begin and end without physical presence. In conclusion, we have the inevitable shifts. ADR is not taken over by accident. Yes, ADR is not taking over litigation by accident. It is taken over because it answers the fundamental questions. What do people truly want from justice? That is why ADR is taking over. What do people really want from justice? Do they want to become long-term enemies? Do they want to crumble themselves because of what? They are trying to resolve a dispute? The question is, what do people really want from justice? Not endless arguments, not technical victories, but fairness, speed, affordability, and peace. That is what people really want from justice. Not endless arguments, not technical victories, but peace, speed, fairness, and affordability. That is what people want from justice. ADR delivers all of this as against litigation. ADR delivers peace, affordability, fairness, justice, and speed. That is what ADR does. The courtroom will not disappear, but its dominance is fading. That is just the truth. The courtroom will never disappear. But you see its dominance, it's fading out because of ADR. ADR is now partially, if not in the nearest future, in full, kick out the court system. But I tell you, not in all cases though. So, the future belongs to systems that are faster, smarter, more human. That is the future of the justice system in the world. The future justice system belongs to faster, smarter, and more human ways of resolving disputes. The future belongs to ADR. Finally, don't forget, if litigation is war, ADR is peace. And in a world that desperately needs resolution over conflict, peace will always win. Yes, peace will always win. Stay tuned, subscribe to this channel as I take you through our next episode. Until then, bye for now.